Welcome to this Legal Aid New South Wales Law Week webinar, Meet the Ombudsman. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. To start with, on behalf of all the agencies participating in this webinar today, we would like to acknowledge the traditional owners of the land from which we are broadcasting. For me, that's the Widjabul-Waiable people of the Bundjalung Nation. We would also like to pay respect to the elders, both past and present, and extend that respect to any Aboriginal or Torres Strait Islander peoples joining this webinar today. I will now introduce our panel. Today you will hear from the Australian Financial Complaints Authority, also referred to as AFCA, and representing AFCA we have Brenda Staggs, Senior Ombudsman. Good morning, Brenda.
Morning, Bridget.
Secondly, you will hear from the Telecommunications Industry Ombudsman, and we have Wendy Wang, Assistant Ombudsman Dispute Resolution from the Telecommunications Industry Ombudsman today. Good morning, Wendy.
Good morning, Bridget, and good morning, everyone.
Our third agency presenting this morning is the Energy and Water Ombudsman New South Wales, also referred to as EWON. Today from EWON is Helen Ford, Deputy Ombudsman, and Narelle Brown, Community Engagement Officer. Good morning, Helen and Narelle.
Good morning, everyone.
The fourth agency you will hear from today is the Healthcare Complaints Commission, or HCCC. Excuse me. On our panel from the HCCC today, we have Nicole Lawless, Director of Proceedings and Executive Director, Legal Services. Good morning, Nicole.
Good morning, Bridget. Good morning, everyone.
We are also joined on the panel today by Dr. Craig Latham from the Australian Small Business Family Enterprise Ombudsman. Good morning, Dr. Latham. Dr. Latham may not have been able to join us yet, but I'm sure he'll be with us. You are here?
In the corner. It's me in the spotlight over there. So.
Thank you, Dr. Latham. Good morning.
Good morning, all.
And the final but not least agency you will hear from today is the New South Wales Ombudsman. Jacqueline Friedman, Deputy Ombudsman, Complaints and Resolution, is representing the New South Wales Ombudsman today. Good morning, Jacqueline.
Morning, Bridget, and good morning, everybody.
I'll now hand over to Brenda Staggs, Senior Ombudsman from the Australian Financial Complaints Authority, to start their presentation.
Hi, everyone. As Bridget said, my name is Brenda Staggs and I'm a Senior Ombudsman at the Australian Financial Complaints Authority. I'm coming to you from Gadigal country of the Eora Nation. I'm going to talk today briefly about what all of our schemes share in common, and then I'm going to talk specifically about AFCA. Because I get so excited about the work we do at AFCA, I can tend to talk a bit, but we're all going to make sure that we talk so we have enough time for each of us to tell you about our services. So if you have any additional questions, there'll be some handy information that Bridget can provide to you in the Meet the Ombudsman handout PDF. Next slide, please, Bridget. So the underlying principles that all of our schemes have in common are underlying principles generally of external dispute resolution. So firstly, accessibility. Our services should be accessible to all of you and all of your clients. Most of us provide various channels for the services to be accessible, including by phone, to lodge a complaint by phone, over the internet, or by post. All of our schemes are independent. So that is, we're neither advocates for consumers or people who've consumed the services or the people who are complaining, depending on which ombudsman service you're referring to, or the industry or the government body that you or your clients may be complaining about. Completely independent, and all of us use what's called an inquisitorial system. So we ask questions of both the parties to determine what the fairest outcome will be. So that takes us to the next underlying principle, fairness. So the Ombudsman schemes will generally take into account the law, good industry practice, and fairness in all the circumstances. So those are the things that we'll take into account when looking at the dispute between the parties and trying to provide the party with an outcome that resolves their complaint and puts them on a good step going forwards, hopefully so that they can continue their relationship. The next principle is accountability. So all of the Ombudsman services provide data on the number of complaints that we deal with, the outcomes of those complaints, and that's all quite transparent and available to you. AFCA provides data every 6 months and also provides data to the companies that we receive complaints about so that they can improve their service. And then the last principle is efficiency and effectiveness. So when we look at the next slide, where we're comparing the court process as opposed to EDR, one of the things that we look at is trying to be as efficient as possible. Now, so here are some of the reasons why you and your clients might want to consider external dispute resolution versus cost. Firstly, versus court, not cost. But firstly, time, stress, and cost. I know that when I was a lawyer in community legal centres versus when I was a lawyer in private practice we went to court quite often. And the level of stress that the clients experience when going through quite a formal process was much higher than the stress that my clients going through the EDR process when I worked in community experienced. Also the cost. All of our ombudsmen are free to complainants or consumers. You don't need a lawyer to lodge a complaint with an EDR system, and you don't have to generally appear before an EDR body like you do sometimes in courts, which can be really nerve-wracking for some people, and particularly for vulnerable people who don't feel comfortable standing up and presenting their case in a more formal setting. Forms. So generally speaking, I think with all of us, you only need one form. For any of you who've taken a client through court or been to court, there are several forms that you'll need to fill in throughout the course of the process. So that's another benefit to your clients or to the people that you see. In most of our cases and with all of the services, the disputes resolve quite early on by mutual agreement. So that can even take the stress out of it further. And ombudsman schemes can generally offer a wider range of outcomes than the court is limited to. Next slide, please, Bridget. So now I'm moving to things that are specific to AFCA. So we are the Australian Financial Complaints Authority. Any of your clients can bring a complaint to us if it involves a financial service. So we're looking at things like complaints against banks, insurance companies, in relation to investment advice or superannuation. AFCA's role involves resolving complaints. So that's what we try to do, is resolve the complaint between the financial firm and your client as quickly as possible. We have another function, which is a systemic issues function, which is another reason why you or your clients might want to lodge a complaint with us. So we can not only identify issues that affect a particular person, but if they affect a group of people, what we can do is launch a systemic issues investigation, which means that if it affects more than one person, we can work with the financial firm to provide remediation to a large group of people and also work to change that financial firm's behaviour or correct the thing that they're doing that isn't appropriate. We support regulators by reporting certain matters to them and promoting awareness of our service so that more people can have access to us. Next slide, please, Bridget. So the types of complaints that we can consider. So we can consider a wide variety of complaints. So things like if there's an error in the banking transactions or credit listings, so credit report issues. If you're having difficulty repaying loans, credit cards, or short-term finance, where the short-term financier is a member of AFCA, and that's the main area that I specialise in. So I specialise where people are having difficulty meeting their payments when they're due and payable. Some of the things that AFCA can do where a person is in financial difficulty is look at whether a short period of non-payment is appropriate to help the person get back up on their feet, or if we can vary the loan in some way to make it affordable over the long term. Denial of insurance claims such as car, home and contents, pet or travel cover, inappropriate advice and superannuation. If we can just tab to the next bit of the slide, thanks. And next slide, thanks, Bridget. What we can do. So during our process, if it gets to a final determination by an ombudsman, so I'm one of the ombudsmen who can make a decision, if your client or yourself who's lodging the complaint, the person lodging the complaint accepts the determination, then it becomes binding. The financial firm must take the action that the determination tells them to take. And things that we can do include paying a sum of money for financial loss. So if you've lost money as a result of some of the action that the bank has taken or the insurance company has failed to pay a claim, we can order them to pay a sum of money for financial loss. We can order them to meet a claim under a policy of insurance, both general and life insurance. So for example, if you've been affected by a storm or a flood and we determine that the insurance company should pay out under the policy, we can make the insurance company do that. Releasing security over a debt. We can also order a change, as I was talking about with financial difficulty before, on repayment, waiving or varying an interest fee or charged. We can find where a loan has been provided irresponsibly. So if someone has provided you or your client with a loan they can't afford at the time, we can take action to show that ensure that the proper compensation is received for the provision of that inappropriate loan. And we can also make an award for non-financial loss, so that's stress associated with the behaviour of the financial firm, how long it's taken to resolve, any breaches of the law that may have occurred, of up to $4,500. Next slide, please, Bridget. So when you get to AFCA, what you can expect is that your initial dispute or complaint will be taken by a registration and referral officer who will assist you with lodging that complaint. It will then go through workflow. We will make sure that we have jurisdiction to make that decision very early on, and then it'll flow to case management, where you or your client will have a dedicated case manager who will review the information that's been provided to them and try and negotiate an outcome. If no outcome can be negotiated, then what happens is we move to the conciliation stage, where we have a specialised conciliator sit down with both of the parties to try and reach an agreement. If that doesn't work, there's a preliminary assessment, and following that preliminary assessment, either of the parties can choose to accept it, or if one of the party chooses not to accept it, it goes to a decision. And as I said previously, the decision that is made, if it's accepted by the complainant or the person who lodges the complaint, then the financial firm must do what the decision says. So tips for bringing a complaint to AFCA. Please don't worry about articulating the law perfectly. That's what we're there for. We practice in those areas of law every day. Please let us know if there are any vulnerability issues with you and your client so that we can tailor our process to make sure that you have access to our service and that we really understand the complaint and the nature of the dispute that you're having with your financial firm. Please keep communicating with your client and provide us with appropriate documents. So things that we'll often require that people may feel uncomfortable providing us with are statements of financial position. That just helps the ombudsman or the caseworker work out what's the best way we can help the person moving forward. Please collaborate with us during the process and provide us with any feedback. We're always open to taking it. But please know that sometimes the complex issues, and we do deal with some very complex issues, tend to take longer. Next slide, please, Bridget. We also have an engagement charter, which now outlines the standards that parties can expect of AFCA and also how we expect the parties to cooperate during the process, which is by being fair, respectful and cooperative. So you can know that when you or a client lodges a complaint at AFCA, that you will be respected by the AFCA staff member and also be respected by the financial firm. Next slide, please, Bridget. So that's it from me today. For more information, You can follow us on social media, or you can, once you have this PDF, we do have, I think it's 22 fact sheets available on our website about the services that we provide and the remedies that we can provide and what help you can explain in relation to all the various disputes that you can lodge at AFCA.
Thank you very much, Brenda. I'll now hand over to Wendy Wang, Assistant Ombudsman Dispute Resolution from the Telecommunications Industry Ombudsman, to speak to you about their agency.
Hi, everyone. Good morning. It's great to be here today. I'm coming to you from Melbourne on the lands of the Wurundjeri people. My name is Wendy Wang. I'm the Assistant Ombudsman of Dispute Resolution at the Telecommunications Industry Ombudsman, the TIO. Really excited to be among like-minded people here today. In our work, we're all committed to helping consumers understand and access their rights when they can't fix a problem with their telco provider. So thanks for inviting me to share a peek into our world. In the next 15 minutes, I hope you'll gain a clear understanding of how we can help. At the TIO, we want to help people to stay connected. More than ever, staying connected is critical for earning income, for study, accessing essential services, making social and family connections, and for our well-being. Now think about the internet device that you use the most. Here's mine. I outsource everything to this: my contacts, my banking, my health data, photos, passwords, and sometimes my relationship. I'm not ashamed to say my phone helps me keep track of all of those ever important dates. You are likely to be just as dependent on your preferred internet device. More than ever, it's critical that consumers can rely on phone and internet services they sign up for, and this is where we can help. The TIO is a free and independent dispute resolution service for Australian consumers, and when the relationship between a consumer and their telco has broken down, we're the place to go. We work with consumers and telcos to resolve those issues as efficiently and as effectively as possible so people can be connected again. So today what I'll do is walk you through our process. You'll hear me use the word consumers a lot. Consumers includes residential consumers as well as small businesses and their representatives such as financial counsellors. You'll also hear me use words like disputes, referrals, conciliation, investigation. I'll explain these as I go. I'll also talk about how we help improve the way the telco industry how we improve the telco industry more broadly through our systemic investigations work. Who we are. So who are we and what do we do? The scope of our service is pretty simple. We deal with individual and systemic complaints about phone and internet services. We promote the fair resolution of these complaints, and we provide information analysis to our stakeholders so the industry can continue to do better, and so consumers have the information they need to stay connected. Next slide, please. Thank you. So this is something that Brenda mentioned before, I think, the benchmarks. So similarly to AFCA, our service complies with the benchmarks for industry-based customer dispute resolution, and they're the front and centre of how we go about our work. I think Brenda explained them pretty well, so I won't go into it any further, but our purpose is to provide fair, independent and accessible dispute resolution services and, yeah, comply with those benchmarks. So the next slide, before I go on, you might be interested to understand the scale of our service and the top issues we worked to resolve in the last financial year. Our teams communicate with a lot of people daily. On average, the team that takes calls from our 1800 number and processes online complaint forms will collectively respond to almost 6,000 contacts every week. In the last financial year, we received 119,400 complaints. While the overall complaint volumes have declined for the third year running, complaints from small businesses actually reached a 3-year high at around 20,000 complaints. And we learned that the most common reason for a consumer to contact us continues to be a problem with their bill and poor customer service. For a number of years, complaints about internet services made up the largest proportion of our complaints. Recently, this has actually changed, and our most complained about service type now is actually mobile. So next slide, how can we help? Our complaints process starts when a consumer contacts us with a problem they haven't been able to solve with their telco. They may have stumbled across us on a social media post, searched for us online, been referred to by an agency or other contact, or met with us at an outreach or community event. The consumer will complete an online form from our website, call us, or in rarer circumstances, send us a fax. It still happens every now and again. So some of the phone and internet problems we can help with include where someone has agreed to something they didn't get, a phone or internet service that isn't working as they would expect it to, had their phone or internet service cut off, received a bill they believe is wrong, is having trouble paying their bill, or has been asked to pay a debt that isn't theirs or a debt that they cannot afford. So let me step you through the consumer experience, starting with our early resolution process. Early resolution officers are the first point of contact. They listen, ask questions, and document each complaint before referring it to specialist teams at the telco. We call this the referral. If the issue isn't urgent, the telco will be given 10 business days to contact the consumer and fix the problem. Where there is an urgency, we require the telco to resolve the urgent issue in about 2 business days. And in the case of a medical or safety risk, we actually do also follow up with consumers to ensure the issue has been resolved. So around 85% of complaints we refer to telco are resolved here. The next part of our process is the dispute resolution process. Now, this is the area that I look after. So if a consumer tells us a complaint is not resolved after we've referred it off, and they'd like to keep going to find a resolution, the complaint is assigned to a dispute resolution officer. It's their job to assist the consumer and their telco reach a resolution by conciliating or investigating the complaint. The officers are skilled in understanding all of the legal and technical issues involved in these complaints and in helping the parties find a resolution. I like to say our craft is not happiness, it's helping parties reach a pragmatic outcome that they can live with. Often it's a pretty good sign it's a fair outcome. The next slide is around diving deeper into the conciliation process. In many complaints, agreements will be reached by conciliation. That's where both parties speak with each other to negotiate an agreement with the help of us as a third independent party. So through the conciliation, the officer will work with both parties to suggest options and facilitate discussions to reach agreement. That is so both sides can feel that sense of ownership of the outcome. If an agreement is reached, we'll confirm this in writing, and that's where the complaint ends. Now, if an agreement is not reached through this process, we will investigate, which is on the next slide. So that is when we will ask for more information from both parties to give greater context and allow us to form views about, the rights and obligations of both parties and make a decision on the outcome of the complaint. In all of what we do, we apply a really overarching principle, which is considering what is fair and reasonable in the circumstances, but of course having regard to the law, relevant industry codes, guidelines, and good practice. So I've stepped you through the dispute resolution process, but that's not the end. Stay with me. We've also got an important role in improving outcomes on a systemic level for consumers and providers. So when you handle 120,000 complaints a year, you've got a lot of data at your fingertips. I think about data like a giant bucket of Lego, and I've seen a lot of it because I've got a young son, so that's probably why that's in my head. We've kind of got lots of smaller sorting buckets ready to build a bunch of Lego models that each have their own stories. Our data helps us find and build a really multi-dimensional view of phone and internet issues. So when I think about our annual and quarterly complaints data reports, they tell stories of complaint trends and insights. They're kind of like the regular pieces of Lego. We know how they fit together, and that, you know, the gradients may shift a little over time, but sometimes other stories really only become apparent when you tip out the whole big bucket and get up close and see what else you can make. And that's where we get to systemic issues, right? So that's a problem with a system, process, or practice of telco, of a telco or telcos. So it's one that may negatively impact many consumers or impact a particular type of consumer. We'll investigate systemic issues on a really broad range of topics, including billing, privacy, accessibility, sales practices, technical faults, scams, and more. The three main sources that inform us about possible systemic issues is one, our people. So our teams are well placed to identify systemic issues because they're listening and responding to a really high volume of complaints. So, you know, they're really well placed to go, hang on, I think I've seen this before. They'll alert the policy and systemic issues team by flagging these complaints. In parallel, our reporting team examines complaint trends, you know, daily. A spike in complaints about one telco or a specific key phrase, even a postcode sometimes, we'll have them working closely with the policy and systemic issues team to see whether the trend is indicative of a broader systemic problem. Finally, we hear back from our external stakeholders, such as financial counsellors, regulators, consumer advocacy groups who may flag concern with our office, and then we can circle back and look at our complaints and see whether that issue is prevalent. So what do we do when a systemic alarm goes off? First, we consider how many consumers are affected that we know of, and we know sometimes that can just be the tip of the iceberg. Do the complaints show repeated conduct by a telco that breaches obligations or that we don't consider fair and reasonable? If those kind of threshold questions are met, we then look at, you know, the potential impact on consumers, the timing and urgency of the issue, and whether in some cases a regulator such as the ACCC or the ACMA is better positioned to look at it. If we decide to take an issue on, we start a systemic investigation, and we use the insights of that investigation to drive improvements so that learnings can be applied to improve the experiences of everyone, not just consumers who have made complaints to our service. We achieve this by working with providers to make improvements to their systems, practices and procedures. We raise awareness of issues and share that information with our stakeholders, and we make recommendations for change. But our work doesn't end there. We continue to monitor the providers' complaints, the telcos' complaints, and follow up with them to discuss how they're progressing with our recommendations. The outcomes of investigations are often shared with the telco industry in systemic investigation reports more broadly, and sometimes for specific issues that they'll be referred to regulators as well, who may then take enforcement action. So the next slide covers some systemic publications that we've released recently. The most recent one was in relation to a report about the consumer impact of fraudsters getting access to phone and internet accounts. We know now with, you know, all our services tied to, you know, our mobile phone numbers, you know, when you access MyGov and your bank, often you have to complete the authentication with your mobile phone. All of that makes this area really fraught for fraudsters. The report shares findings and insights gained from a number of systemic investigations conducted in that past financial year, as well as a review of over 500 complaints from consumers who said they'd fallen victim to telco account-related fraud. So our aim in publishing this report is that telcos and consumers learn what they can do to protect telco accounts from unauthorised access. So while we don't publish the outcome of every systemic investigation we conduct, we publish reports about issues where we think there's a broader public interest. And the reports often contain findings about the root causes of the systemic issue and the impact they've had on consumers. We publish recommendations for telcos about what they can do to fix the problem. And we also create sort of tips and resources for consumers about what they can do to help avoid getting into these issues themselves. So I think that's close to the wrap. I think we're up to the last slide. Thank you. So look, the telco industry is complex and it changes really quickly, while consumers' expectations of their phone and internet service continues to grow. So yeah, we hold SETI to our purpose to provide a fair, independent and accessible dispute resolution service for consumers and small businesses, and to improve outcomes for them. I like to see it as just cutting through all the complexity and confusion. We're the place to go when the relationship between the consumer and their telco has broken down. We're the place to go where the conversation can really start again, and people can stay connected by resolving those problems before they escalate. It's our job to listen to complaints, guide consumers and providers to help reach an outcome they're both satisfied with, and we're here to help you when it comes to these problems. So thank you. That ends my presentation, and I believe I'm handing you over to Helen Ford from EWON.
That's right. Thanks very much, Wendy. We will hand over to Helen Ford, Deputy Ombudsman from the Energy and Water Ombudsman. Thank you, Helen.
Thank you very much. Thank you very much, and delighted to be here. And I'm joining you from Gadigal land of the Eora Nation in Sydney. This is delightful being on this panel because so much of how we approach what we do is so similar, and then we have slight variations. So I'm thoroughly enjoying everyone's description of what we do. Thank you. So I'm the Deputy Ombudsman at the Energy and Water Ombudsman New South Wales, that we abbreviate to EWON because that's far too long to say all of the time. If I could have the next slide, please.
Helen, I'll just let you know you're coming through a little bit faint. It might be an issue for some of the audience.
Oh, is that any better now, Bridget?
That's much better, thank you.
Yeah. Dropped microphone thingo. So we focus on electricity and gas customers in New South Wales and some water customers, and in the way Brenda and Wendy have described, fundamentally, if someone can't solve a problem with their energy and water provider, we offer a free, fair and independent mechanism to actually try and resolve that dispute, looking at what's fair and reasonable in all of the circumstances. And on the next slide, you can see who can come to us. So we're here for both residential customers and also small business customers. And you as community workers and advocates can bring a complaint to us, as well as customers directly themselves and small business as well. So the next slide shows you who our members are. About 6 or 7 years ago, we used to be able to fit all of our members on one slide when we had about 40 members. We've now got 350. So a really significant expansion in the last few years. All of the big electricity and gas providers who operate in New South Wales have to be a member of EWON. Names you would be familiar with, I'm sure: Energy Australia, Origin, AGL, and then some of the mid-sized providers as well. Poles and Wires guys have to be members. Ausgrid, Endeavour and Essential, and Gemina for gas. But the reason for our significant increase in size is in 2018, embedded networks had to become members of EWON as well. And embedded networks are basically private electricity networks where you get your energy within the residential setting where you live. Most commonly caravan parks, retirement villages and residential complexes. And some water providers have to be members of EWON. So the big licensed providers, Sydney Water, Hunter Water, Water New South Wales, and then we also can have voluntary council members, and Shoalhaven Water, who is a council provider, is a member, and then the small private water providers who are licensed under the Water Industry Competition Act. That's a very comprehensive coverage though, so really, if in doubt, just assume that we will have coverage of your provider. And what can we look at? We look at many of these issues are similar to those my colleagues have spoken about. Billing and customer service are our top two complaint about issues as well, unfortunately. Billing is around high and disputed bills, fees and charges, credit, obviously disconnection, arrears, payment difficulties. Customer service can be a lack of a response, poor communication, inaccurate information. Transfers, if you move house or you try and transfer your electricity or gas account and there's a hiccup and you suddenly end up with no supply, we can help with that. Digital or smart meters. Some of you probably have transitioned from the old analog meter with a little whirly thing that goes around to a smart meter. The transition isn't going as smoothly as perhaps it could have in New South Wales, so we deal with quite a few complaints about that. Marketing, land access issues, providers, particularly the networks, needing to come onto your land if there are any issues there. And if you move into a new development or a new property and there might be confusion about your metering, issues like that. Really, if in doubt, come to us and our staff will be able to help either by letting you know we can assist or pointing to somewhere else that's a more appropriate avenue to get some assistance. And if I could go to the next slide. So when in particular is it a good idea for you as community workers to refer to EWON? If you've got a customer who's threatened with disconnection or has been disconnected, if someone's experiencing problems getting a connection, or if they haven't received a bill for over 9 months, which sounds a little bit startling, but is not uncommon. Or, and this really goes to our fair and reasonableness role, if in your opinion you think a provider has not been particularly reasonable and has been too harsh or hasn't offered assistance to a client. If a provider is demanding a large upsum payment or is asking for a payment plan that really is unreasonable looking at your client's circumstances, or the provider just plain refuses to negotiate about a problem, or gives you or your client incorrect information, or particularly good reasons to refer someone to EWON. Next slide, please. Why refer someone to EWON? We know that many of you have got great expertise in some of these areas, having a lot of experience working to resolve problems for your clients. Our expertise complements yours. Energy particularly is a very complex area. I've worked across quite a lot of subject matter area before I came to EWON, and I have to say energy really does tend to win the prize, I think, for complexity and very, very strange language most of the time about using words that don't really mean what they sound like. And we obviously have staff who at that complex end have considerable expertise. We also consider both each case individually to try and help get a fair and reasonable outcome, but we also look at the bigger picture. And in the way Wendy spoke about, we do a lot of work collecting information from our complaints to build that bigger picture. And this is the area that I specialise in at EWON, looking after our policy and systemic issues work. And it really is that ability for us to see across all of our members. Some of our better members will be doing root cause analysis of their own complaints and identifying systemic issues. Some are not resourced to do that. And of course, as an ombudsman scheme, we can see complaint types and issues across all of those 350 members. So sending something to us means we not only can assist the individual customer, but we can really look at how to drive positive change using that data from that whole body of complaints. Next slide, please. This is just one example of a change that we as Energy and Water Ombudsman contributed to. And I'm actually able to talk about the name of the provider because this was a very well publicised decision by the Australian Energy Regulator. EWON received a series of complaints over about a 6-month period where customers were who were experiencing vulnerability told us that they had been asked to make upfront payments or seek financial counselling before they were, rather than being admitted into the provider's hardship program, which all energy providers are required to have. And some alleged that they'd actually been disconnected or had their payment plan cancelled after they'd missed a payment. We worked on those individual complaints, but rapidly realised this seemed to be a systemic issue. And as part of our systemic issue investigation, we referred these complaints with our analysis to the Australian Energy Regulator. As an ombudsman, we're not a regulator, but we can provide information and do provide information to the regulators when we see issues of concern. The AER did an investigation itself and found that the provider should have offered customers access to their hardship program or a payment plan instead of disconnecting them. And Alinta responded really well to the findings of the AER and waived over $1 million in customer debt from more than 400 affected customers. And they also conducted an internal review to improve their systems and stop such a thing happening again. So a really good example of where what were not an enormous number of complaints were very, very important in actually helping bring about a very significant and positive outcome for a large number of customers and led to real system improvement in the provider. Next slide, please. We're lucky at EWON in that our charter, where our jurisdiction comes from, explicitly says we have to do systemic issues work. And we work with providers when we have identified systemic issues to get to the bottom of what's happening. We also provide data and case studies to government and regulators to help them make really good evidence-based decisions. And around 12 months ago now, we started a series of reports called Spotlight On. And we've only done 5 so far because we really save these for those really wicked public policy issues around energy or water that just seem intractable. And most of the regulators kind of go, oh, we wish someone else would look at this because it's really, really hard. We do go to a lot of effort to make sure that our fabulously big-brained policy officers don't actually explain it in quite the way they normally would. Our communications staff do a really great job at working with them to make these reports really accessible. They're only quite short if you have a look on our website. Lots of pictures, which I need to understand some of the complexity. And our focus is really on saying it's a call for action, and we keep pursuing the Spotlight On messages long after we've published the report. They're not a set and forget series. They're really a call to action where we continue working with the decision makers to try and advance solutions. By way of example, one of the reports was on what's a regulatory gap about how you are charged and your consumer protections if you live in an embedded network that has a bulk hot water system. So instead of having your own hot water arrangement in your own unit, it comes from a central tank somewhere in the property. There's a lot of complexity, a lack of protection about how you can be charged, a lack of access to some consumer protections that other water customers have. And it's one of those things that could have a national or a state solution, and it just needs some very smart people in the policy realm in those settings to actually work together. We're about to publish next week our next spotlight on, which will be on consumer protections about the new energy products that are emerging in the market. So solar, batteries, microgrids, all of the products that you'll be reading a lot about in the press at the moment. There's a lot of innovation, but by definition, that means many of these things don't fit cleanly into any of the existing protections. And our spotlight on is highlighting that it's far better to get those consumer protections right from the beginning, including access for those customers to independent dispute resolution in one place from the start, rather than try and retrofit after the fact. So we shall be being a squeaky wheel with our other colleagues across different state energy and water ombudsmen talking about that. Next slide, please. We also use those complaint stories and trends and analysis in submissions to government and policymakers. We know from our engagement with regulators that they don't have direct visibility of customer story and customer experience. And as Ombudsman, we can actually provide objective, evidence-based case studies that actually help them understand the current situation, to look at how what they're proposing might impact that situation, and where there might be issues that they were not aware of, to actually help frame what they decide to do. We publish all of our submissions on our website, and they're very case study rich to really help bring alive those customer stories for those who are making decisions. Next slide, please. I just wanted to speak very briefly about the Energy Accounts Payment Assistance Programme that I hope most of you are aware of. It's a scheme where customers can get $50 vouchers towards helping pay for their gas and electricity bills, $300 a bill, $600 limit a year. Community organisations and Service New South Wales both administer the EPA scheme. And there's a list of organisations there you can find that offer EPA assistance. So a really important avenue of assistance for customers in financial difficulty. And on the next slide, you'll see a case study about how our dispute resolution officers were actually able to help a very frustrated financial counsellor who had been trying to get an EPA voucher applied to their customer's account, but because of a problem with the tariff was drawing a blank. They had tried valiantly 5 or 6 times to resolve this, and finally came to EWON, and we were able to work with the provider to make sure the tariff change was implemented. And in addition, the customers' bills were cancelled, they were rebilled appropriately, and in addition to the EPA being applied, they were also given a customer service credit as well, in recognition of the very poor service they'd received. And next slide, please. There's an EPA review that we will certainly be making a significant submission to as well, and I'm sure many of you might be too. We'll raise some of the bigger picture issues around the need for a broader approach for that cohort of customers who are really in entrenched financial difficulty, rather than short-term crisis, which is what EPA was originally designed for. And really calling out the need to have some holistic assistance for customers who are in that situation, and looking at customers who can't currently access EPA, and there are some exclusions that impact quite a number of people. It's the Office of Energy and Climate Change who are running the review, and you can see information on their website about how to participate. And finally, I just wanted to finish up by talking to you about a couple of ways that we can continue working together with you and your organisation. If you produce a consumer newsletter, we can provide articles for you or social media information to provide information about energy and water issues to your consumers, your target audiences. They're free, basic articles. We try and explain the complex simply, and they're all aimed at consumers. And please contact Narelle if you would be interested. And a plug for our newsletter. Jump onto our website and click subscribe, search subscribe, and we send out consumer newsletters 3 or 4 times a year. And final slide, I think. We also, our outreach team, are really happy to come and deliver presentations face-to-face or online to any of your staff or consumers. We'll tailor them for individual groups or topics. We love coming to an expo or a festival. Our outreach team is just beginning to hit the ground and get out to do face-to-face work again. So please contact us. And we have a significant number of fact sheets for consumers on our website, and also promotional materials that we're very happy to send out to you if you would like to distribute them yourselves. And the contact details are there for you to get in touch with us. And final slide is just our contact details there, either for you or your clients to lodge a complaint or to get in touch about any of the other issues I've talked about. And thank you very much, and back to you.
Thank you very much, Helen. Just before I introduce our next speaker, I have neglected to remind the audience, and Brenda did refer to it, that there is a PDF copy of this presentation as a handout on your control panel, so you can download that while you're participating in the webinar, but we will also send it by email to everybody participating in the webinar today. Now I'd like to introduce you to Nicole Lawless, Director of Proceedings, Executive Director Legal Services from the Healthcare Complaints Commission, to present to you.
Thanks, Bridget. Good morning, everybody. I'm delighted to be here and, as Helen said, be with some like-minded colleagues who are in the complaint handling business. I also wanted to thank Brenda for her introduction and to highlight some of those key principles that are common to all of us. I'm also coming to everybody today from Gadigal lands in the Eora Nation in Sydney. So the Healthcare Complaints Commission, we are a little bit different to the bodies that you've already just heard about that are industry-based bodies. We regulate, as it sounds like, the healthcare system in New South Wales. And basically our mandate is to protect the public health and safety, and that we do that by resolving, investigating, and again, somewhat differently to the other entities you just heard from, prosecuting complaints about healthcare providers. We are independent and we're set up under the Healthcare Complaints Act 1993, so we're a statutory body. Basically, we have a really central role in maintaining the integrity of the New South Wales health system, and our overarching aim is to protect the health and safety of individuals and the community. And how do we do that? Well, we receive complaints about a variety of health service providers, and they will be health organisations, so hospitals, medical centres, day surgeries, registered practitioners, and there's a distinction I'll get to in a minute, registered practitioners, which will be doctors, nurses, chiros, physios, psychologists, and then unregistered practitioners. And unregistered practitioners is an interesting space that I wanted to spend a moment just touching on, because I think a lot of people are unaware perhaps that this is a core part of our work. And unregistered practitioners are actually a burgeoning industry. So for example, that will include sonographers, massage therapists, counsellors, cosmetic surgeons, aged care workers, and basically anybody that provides a health service we can accept complaints about. Next slide, please, Bridget. So essentially what we're aiming for is a better, safer healthcare system in New South Wales. And as the slide said, and common to I think most complaint handling bodies, at the centre of what we do is that people have got the courage to come forward, to speak up about their issues, to make the complaint in the first place. And also key to success is that providers are open to respond when things go wrong. and engage in a process to remediate or address the conduct. So it's only through individual complaints that there's potential to heal and knowledge to drive improvement in care and treatment. Next slide, please, Bridget. So who can make a complaint about a New South Wales health provider? Basically anybody, any person can make a complaint. So it can be the person that was subject to the conduct, so the patient often. It can be a family member, a partner, a friend, a carer, a legal representative. It can be a member of parliament, or indeed it can just be somebody who has witnessed something that they're concerned about. There's some mandatory requirements as well for health professionals to notify regulatory bodies. And we also get obviously referrals from other regulatory bodies such as the Ageing and Disability Commission and from the New South Wales Police and sometimes from the New South Wales Ombudsman and other bodies. Next slide, please. So how can members of the public raise concerns about their healthcare? How can you assist your clients to do so? At first blush, we try and get people to resolve the issues locally. Again, probably a relatively common feature to my colleagues on the screen. Ideally, and where appropriate, try and contact the doctor or the health organisation or the provider to see whether or not you can resolve the issue locally and to see whether you can get resolution. Often we find that providers will welcome feedback and will try and resolve complaints locally. There are also tips on our website for preparing for that kind of interaction. However, often they can't be resolved locally, and that's when it's appropriate to escalate to us. Also, as I said, sometimes it won't be appropriate, particularly if there's a serious complaint or egregious conduct on behalf of the provider. You're welcome to come straight to us. Next slide, please. So all complaints must be in writing. That is a feature of our Act. But of course, it's really important to us to make sure that there are no barriers to making complaints. And we are more than happy to assist people to reduce those complaints to writing. And we've also got an online portal that is a good way for a complaint to be made. It provides prompts about the information that should be provided, and it's quite easy to navigate. Of course, not everybody wants to use a computer or has a computer, so we take complaints in other ways. People can come to our office directly. We also have a phone service, obviously, and people can phone us, request a form, we'll send that out and that can be emailed back. We've got multiple forms in multiple languages. We've also got a really good inquiry service. So sometimes you just want to talk to a human being and get an answer straight away. So we would encourage you in those situations to phone our inquiry service, and they can direct you to the right way to make a complaint, or indeed, sometimes we need to refer a complaint to another agency such as the Aged Care Quality and Service Commission, Safety Commission. And the inquiry service will be able to direct people to the appropriate body. Next slide, please, Bridget. So what can we do? So essentially, we've got a couple of options available, or a couple of pathways. If it's a serious complaint, we can investigate it and then we can prosecute it. Or if it's appropriate, we can divert it to our resolution service, which is quite similar in its features to some of the programs that you've already heard about this morning. Alternatively, we can also refer complaints to our co-regulators, because most of the registered professions that I referred to earlier have actually got professional councils that are responsible for regulating their peers. So that might be the Medical Council, the Nurses and Midwifery Council, the Physio Council, the Psychologist Council. And if it's a less serious complaint, it might be appropriate for one of those bodies to deal with it. Sometimes we won't take any further action. It might be a variety of reasons for that. But despite that, you know, it's always important that the complaint is made. We will keep a log and a record of complaints that are made about providers. And just because it doesn't go anywhere on that particular occasion doesn't mean that it shouldn't be made, and it doesn't mean that it doesn't on some level assist with the better improvements that can be made to the healthcare system. Some of the things that we can't do, which again might be a little bit different to some of the other ombudsman officers that you've heard from, is we can't force a healthcare provider to provide a particular service. We can't force people to apologise. We can't order somebody to refund money or provide a service at a reduced cost. And similarly, we can't award damages or compensation. Another one that comes up frequently that we also can't do is we cannot direct that medical records be changed. And that's something that we're often asked to do. And unfortunately, that's just not within our power to do. I wanted to touch briefly on 2 case studies, just to highlight the kinds of work that we do and the kinds of outcomes that could be expected, particularly, as I said earlier, in the case of serious complaints. The first case study that I wanted to talk about is in relation to a prosecution, and that falls within my remit. So as the Director of Proceedings, that's a statutory role that I hold, which is responsible for prosecuting health practitioners for misconduct, and we go before the tribunal, the New South Wales Civil and Administrative Tribunal, NCAT, and we prosecute health providers for disciplinary offences. This particular case study involved a ENT surgeon by the name of Dr. von Marburg, and similar to Helen, I can talk about that because it was publicised and it was in our annual report. And this particular ENT had an 8-year span of conduct involving over 30 patients where he performed surgery without clinical indication and without consent. And what that means is that it wasn't medically necessary, it wasn't clinically necessary to perform that surgery. He didn't provide adequate aftercare. He failed to keep proper medical records or any medical records in some patients' cases. He then created false medical records. He made false patient admission forms. He breached conditions that were on his registration. And then to top it off, he also provided false and misleading information to the Medical Council in relation to the work that he'd been undertaking. He was also impaired due to an opioid dependence, and he was prescribing to patients, purportedly prescribing to patients, but in fact the medication was for his own personal use. So it was kind of, really, really up there as far as serious misconduct goes. And we prosecuted him, and the tribunal found that he was impaired, and the 2 professional misconduct complaints were proven in relation to 18 different instances of clinical incompetence, basically, and that his patients had subsequently suffered serious consequences, including hearing loss, chronic dizziness, balance difficulties, severe ear pain, migraines, and extreme sensitivity to sound. So they also found that he was incredibly dishonest, and his dishonesty was particularly egregious, and he had no insight, no remorse. So he was disqualified or struck off, in sort of lawyer speak, the register for a period of 8 years. So as I said at the outset, the primary objective is to protect the public, and by Dr. von Marburg being struck off for 8 years, that objective was achieved. So that's kind of at the really pointy end, I guess, of the compliance spectrum. And then the next case study is actually about our resolution service. So another way that we can protect the public but also get resolution for people. And this case study involved a young mother whose baby was really, really sick and required weekly head ultrasounds in the special care nursery. Those ultrasounds were absolutely fundamental to monitoring the baby's condition, and in this particular complaint, the ultrasound had not been undertaken. It was delayed. I think it was 2 or 3 days overdue, and the mother was really, really concerned about what that meant for her baby. So we got involved, and we had her particular issue immediately addressed, and our resolution officers got in touch with the hospital, and the ultrasound was conducted that very same day. But that obviously raised some sort of issues around patient safety. And when we sort of delved a little bit deeper, it turned out that there were some problems with the radiology department because they were worried about the high level of lighting in the nursery, that would compromise imaging if they did the ultrasound there. But similarly, the nursery staff had considered that the transport of these really sick babies through the hospital to radiology was a clinical risk. So essentially through the resolution process, we got the hospital to agree and to concede that bedside ultrasounds and X-ray services for high-risk patients, including newborns, would be the best way forward. So the mother had a voice in this process, and the hospital was enabled to introduce a risk management procedure that was beneficial to the rest of, also future patients as well as the patient in the complaint. Next slide, please. So this is essentially my final slide. So if you do wish to refer a complaint to us or encourage your clients to do so, that's our website. You can visit us at hccc.nsw.gov.au. As I mentioned earlier, we have an inquiry line that is staffed with really expert and compassionate staff members. They're willing to take your calls and direct you to the appropriate complaint handling body if it's not us, or to give you advice on how to best manage a particular issue that you might be facing. As I pointed out earlier, we've also got a portal that is quite easy to navigate and has quite a intuitive way of lodging your complaints. Anytime you have a question, you can call the 1-800 number and you can be put through to whoever it is that's best placed to assist you. So thank you so much. I hope you've learned a bit more about the Healthcare Complaints Commission and the role that we have in preserving the integrity of the New South Wales healthcare system.
Thank you very much, Nicole. Up next is Dr. Craig Latham from the Australian Small Business and Family Enterprise Ombudsman to speak to you. Welcome, Dr. Latham.
Thank you, and hello all, and hello from Canberra, which is Ngunnawal country. I'll start by and I've been really fascinated, especially by the case studies and things, and I've got a few of those, time permitting as well, but and there's a lot of similarities others have remarked on about our service as well, but our focus is around small and family business. Our definition of small is pretty large. It's up to 100 employees. So we cover a lot of territory, and that's up to 100 employees on one side. Normally the stuff we're dealing with is disputes. So on one side of the dispute. So it gets us right up into that sort of SME, the middle of SME, the me part of SME. Look, small business is really important. 97% of all Australian businesses are small business. When you look at the spread then, you get about 60% or so of them of having no employees, but then that other pretty much 40% will have either 1 to whatever employees, but normally at the small end of that, dealing with a whole range of issues as a result. Small businesses employ 4.7 million people, which is roughly 40-something% of all employees, getting up towards 50. Small businesses contribute 422 billion to the Australian economy, about a third of GDP. Some businesses or some industries are largely small business. So when you're thinking about real estate, when you're thinking about agriculture and fishing, and thinking about construction, predominantly those businesses are run by small businesses, or those industries are run by small businesses. Interesting as well, small businesses are the largest employer of apprentices and trainees. So really critical for our economy, but have been through really rough time over the last sort of the coronavirus, but you add into that the bushfires and the floods and the drought before that as well. It's been a really hard period, and so we've been quite busy. And it's made dispute resolution all that much harder because the margins are tighter as well. So some of the stats in this space as well, that MyOb has done an SME success report, and small businesses are buoyant. 12%, not a massive number, but 12% actually said they're now more resilient as a result of all the bad that's just happened. But 50% of them have actually changed their business model as a result of what's going on. So the pivot was really important during the last period. So our office, our functions are advocacy, so helping small business get that voice into government and elsewhere, but assistance, so that's like dispute resolution, like many of the others here as well. But we also take very seriously our role to inform the debate, so data analytics is another thing that we do, and communication is key as well, and we have a communications unit that will deal with social media and getting messages out there. On the advocacy side, we make submissions to various inquiries or other work people are doing, but we do our own as well, so we do our own inquiries, and the Minister can give us an inquiry to do and report back to the Minister as well. And so we've looked at things like access to justice, we've looked at the Personal Property Securities Register and how to improve that. We've looked at how the insolvency system is treating small businesses, tax, there's a whole range of things. And the one good thing about having the acronym ASBFEO is that you won't get anything else when you Google us. So please Google us. asbfeo.gov.au is our home, and you'll see a wealth of material on there about small business, and increasingly so around the data side as well. So we're expanding that and wanting to make our data and other people's data easily accessible for academics, for other people engaged in advocacy, or just informing good policy. In terms of our assistance, so this is basically the dispute work, we get about 7,000 contacts per year. People can come into us via our info line, our telephone line. We've got a direct number that's on our website as well that can come straight to our office here, but we have a dedicated team of people to do the initial triage of matters. But then we've got web forms, we've got email. So whichever form takes your fancy, come to us. What we try to do as part of our role, and it's really critical, it's like some of the others here as well, is we don't duplicate another agency. And so if we're not the right agency, then we will get you to the right agency. And certainly if somebody else, like say AFCA, which we park a lot of business that way, and so we will get a business complaining about insurance, banking, whatever, whether they're an AFCA member, get them to AFCA as quickly as possible in a good form as well. So one of the critical things that we do is help to disentangle what it is that is the problem. So we will try to help the small businesses come to us think through what is it actually that's causing the issue, because sometimes it's the thing that they initially tell us, but sometimes when you dig a little bit, you say, oh, okay, so there's a little bit more at play here, and there may be some other more important things to deal with maybe first or at all as well. We have also got coverage of a number of industry codes. So this is the horticulture, dairy, franchising and oil codes. So disputes in those industries are subject to the provisions of the code, basically getting people off to compulsory mediation / conciliation. Sometimes arbitration voluntarily as well. And so we will again help people make sure that they've followed the steps in their code. So talking to the other side, the key ones to start with. So talking to the other side, and then helping again triage to get them to outside the court system, a way of resolving their dispute that is timely and of lower cost as well. Interestingly, actually I should mention, we also run the small business tax concierge. So when you're at the end of the tether with the Australian Taxation Office, so you've run through the internal complaints mechanisms and escalation points there, we will help small businesses then work out, should I appeal to the Administrative Appeals Tribunal? So get people to get an hour's free advice or heavily subsidized advice for that first hour, and a free second hour should they then go on to appeal. So that basically, again, getting a little bit of sense talked into, is this something worth pursuing? But then if I pursue it, what do I have to do? What are the critical bits that I need to pull together in order to make an effective case before the AAT? Some of the helpful things you'll see also on our website, and this is really one of our key artifacts, is 5 steps to resolve your dispute. And so this is speaking to small businesses and others, but it's just steps them through in a sort of systematic way to understand the dispute, reminds you to talk to the other party. So not just to be upset, but actually say something about it, and write to the other party. So again, then just think about and think hopefully fairly logically about what it is and possible solutions. Then ask for help then after you do that from us or somebody else. And as I said before, if you come to us and you should be somewhere else, we'll get you there. And as a very final step, think about court. But that one, and I could tell you lots of case studies about businesses that have decided court was the option and that it's killed the business as a result. I've talked about triaging disputes. A key part of that is us getting the parties to talk to each other, effectively via us, to try to diffuse what might have been laid, because often we get to see things when they are highly inflamed. And so we, as I often will say, look, there's a story that comes to you, the complainant, there's the story that the respondent gives you. When we go off via a preliminary non-judgmental sort of letter, tell us your side, and there's probably the truth sits somewhere else, right? But we use an interest-based type approach, so where we're trying to understand what are the drivers here, what is actually the dispute, and help the parties talk to each other in a way that is positive and mature, and really helping them lead into a successful result outside of court or outside of having to give up the complaint and lose the relationship. And I did say some stories, and I suspect I'm probably running fairly tight on time. However, I'll talk to you a little bit about quickly some of them. During COVID, it's been really interesting looking at our data around what I'll call payment versus contract disputes. Payment disputes is, as I would define it, would be more like I cannot pay you, I will not pay you. It's not a problem with what was provided, the service or the good, whereas a contractual dispute often has those sorts of elements. What we've seen during this time is payment, COVID, what I call COVID breathing through the economy. Our payment disputes ebbing and flowing. So as businesses start to come out of lockdown type situations, and once they're in free of lockdown, we've seen massive increases in side payments that then go down again as things normalize. It's been really interesting to watch that and see what's happening in the economy. But we are very flexible in our approach, and our legislation actually says to us to act flexibly and efficiently in what we do. So again, we'll look for ways if there are multi-party type disputes. So another dispute we had was in the dairy industry, where dairy equipment was burning the udders of cows. And there was a question about, now, whose fault is this? And there was the manufacturer, there was the person who installed it, there's a person who services it, there's the insurer, there's the farmer, and the cows didn't come to the mediation. But there was a group mediation there of 5 parties, successfully resolved. And again, we did spend quite a little bit of time there getting each of the parties sort of ready and understanding what it is that is actually in dispute. I mentioned the tax cases, a lot of cash flow and JobKeeper disputes. Again, success in a large number of those, because the technical detail was very difficult there, and the materials that small business may not have put forward, we could help them sort of uncover and go to the tax office and have some of the decisions there reversed. Seeing a lot of things in fitness and gyms, again, that's sort of COVID related. Basically, trainers and others needing to get out of arrangements over that time. See a lot of scams. Again, they're hard, and often the other side in a scam is not one that you can get at easily. But an example there was a Hong Kong firm, I believe, running a scam into Australia and taking Australian monies off the Alibaba site. So would advertise on there, take the money off it, so encourage the person off it, and then never deliver. And those significant sums as well. But again, thinking a little bit around it as well, and talking, for example, in that one through Alibaba and getting them to follow it up as well, given that it was happening on the platform, ended up with a successful outcome there as well. Many more cases, media platforms and SEO, search engine optimizers, is a wealth of business for us. But banking disputes, I've mentioned as well, and AFCA, we're always so happy to see there's an AFCA member involved. The ones with who are not AFCA members, and I am going to be talking to some people interested in finance, we would say think really seriously, because if something goes wrong, our experience is it's really hard to rectify. And I will stop there, hopefully not too long over.
No, you've done very well for time. Thank you, Dr. Latham. Our final presenter today is Jacqueline Friedman, Deputy Ombudsman, Complaints and Resolution from the New South Wales Ombudsman. Welcome, Jacqueline.
Thank you, Bridget, and welcome everybody. As with Brenda, Helen and Nicole, I'm joining you from Gadigal country. So if we can turn to the first slide. Who are we? We're a parliamentary ombudsman and part of the integrity branch of government. Since 1975, we've been examining decisions made by New South Wales state and local government agencies and some community service providers. We do this independently and impartially, and government maladministration is our focus. Now, that's a broad term that covers conduct that is unfair, discriminatory, unjust, or simply wrong. We examine illegal conduct, we examine conduct that is legal, but where a law is unreasonable or oppressive. We can also look at whether an improper motive lies behind a government decision, and we can also look at whether a failure to act is unreasonable. Turning now to our purposes, thank you. Ultimately, our aim is to improve public administration in New South Wales so that everyone receives the right services and fair treatment from those agencies we oversight. We also work with government and service providers to improve their services, including how they handle complaints from the public and from their own staff blowing the whistle on wrong conduct. We are in fact the lead agency in New South Wales for the public interest disclosure or whistleblower regime. As well as managing complaints we receive from the public, we are also proactive through various monitoring functions. We are also asked by government to provide independent expert comment on legislative proposals. Turning now to how we achieve our purposes on the next slide, thanks. While we have various means of doing this, such as monitoring certain government programs, I'll focus obviously for today's purposes on complaint handling. We can deal with complaints about most New South Wales state and local government agencies and some non-government service providers and the 10 New South Wales-based universities. Schedule 1 of our Act excludes the conduct of certain people or agencies, such as the Governor, ministers and other MPs, New South Wales Police, and matters involving carrying on of legal proceedings, to give some examples. In the 2020-21 year, we received almost 25,000 contacts from people. Types of complaints we receive are hugely varied, and I'll run through a few recent examples of where we've helped people. A tenant in public housing had suffered quite a large hike in water charges and complained to us. We made inquiries of the agency and were able to secure an independent review with positive outcome, and that person received a credit on future water charges. On similar lines, a university student came to us at the height of the pandemic, having been unable to secure a repayment of $2,000 they had paid in error to the university, and the uni had refused them a refund. Our making of inquiries led to an internal review and eventual reimbursement. And in another matter, where the complainant had been fined for failing to attend court for jury duty, we made inquiries based on her assertion that she had emailed an explanation to the Sheriff's Office. She had in fact used an incorrect email address. However, as a result of our discussions with that office, the fine was eventually waived. Other types of complaints can include matters such as an inmate in a corrections centre being mistreated, an Aboriginal child in out-of-home care for whom placement principles have not been applied, council failing to apply planning laws correctly, or unacceptable delays in finalising a deceased estate. Now, as you'd be aware, government agencies generally offer internal review rights if someone is unhappy with a decision, and ordinarily will require someone to pursue that course first and then come back to us if that does not resolve matters. However, for us to become involved, there does need to be an element of wrong conduct or maladministration. It's not enough that someone is simply unhappy with an outcome. We do need to make choices in what we progress as a complaint, as well as looking at whether wrong conduct is being alleged. We consider the seriousness of the conduct complained of and whether there are any systemic issues, and also whether the conduct impacts vulnerable or at-risk individuals. We aim to resolve complaints where we can through making preliminary inquiries of the agency concerned, and we can also suggest improvements to the agency's processes to prevent recurrences or even suggest action they could take, such as issue an apology where their conduct has fallen short of what's acceptable. Now on the next slide, we'll see some samples of matters. If we turn to the next slide, thank you. Thanks, Bridget. Where we have produced some public reports. So if we do conduct a formal investigation and find wrong conduct as a result, we will issue a public report and table that in Parliament. Now, one of the examples you can see is the Blue Mountains Council matter, where we examine the conduct of safe work inspectors and their issuing of compliance notices regarding asbestos management practices. We found instances where these notices were not justified in being issued and were done so with inconsistent standards being applied. And this had impacts on council as well as on its ratepayers. We made recommendations to Safe Work, the regulator, and they accepted them all regarding the issuing of an apology, the payment of compensation to council, and crucially, improving their procedures and training to prevent similar wrong conduct recurring. In relation to the investigation report here on the strip searching of 3 young people in custody, we found that while these searches were legally authorised, they were not justified by the circumstances. Our report was issued in June last year and the recommendations were partly accepted by the agency. Earlier this month, the Ombudsman actually issued a follow-up public report on that matter on the basis there had been inadequate action in response by government, and this will require the responsible minister to issue an explanation to Parliament. And then the final example I'll draw your attention to is the bright orange one, which is our 2020 report on COVID-19, in which we highlighted shortcomings in the pandemic response. Now, this report was informed by the types of complaints about COVID we had been receiving, as well as action taken by other agencies. Now, our primary observation was that as a public crisis unfolds, it's imperative to have independent oversight arrangements established and clear avenues for complaint handling. And this is analogous, I think, to Helen's earlier comments about securing oversight at the earliest possible stage for emerging technologies. So turning now to our powers and obligations on the next slide. For any complaints that we progress, we can make inquiries with the agency concerned to get their side of the story along the similar lines to what Craig was talking about, to better understand the issues, and this can help us resolve the matter for the complainant. We are held accountable through needing to provide reasons for not pursuing a matter or for discontinuing an investigation we commence. If we do hold a formal inquiry, our powers are quite significant and similar to those of a Royal Commission. Any improvements we suggest to an agency by letter or any formal recommendations we make in a public report will need to address the conduct concerned, they need to be practical and ultimately aimed at improving public administration. So finally, turning to on the final slide, what factors would apply in considering whether to submit a complaint to us or whether to refer someone to us to make a complaint? There are some threshold issues, of course. Firstly, to consider whether we have jurisdiction over the agency or person being complained about. You can find a wealth of information about that on our website, ombo.nsw.gov.au, and also on our online complaint form page. There is a lot of information along those lines. And secondly, ask whether it concerns conduct we can examine. But if it is a matter that is ultimately not one for us, we do aim to add value and provide assistance to people to find an appropriate path, for example, by warm referral. And even if we don't take action, aggregated complaints data does allow us to build up a picture of sectors of the government services. So a complaint made to us certainly won't be in vain. Thank you.
Thank you very much, Jacqueline. You've all been so good at keeping to time that we now have ample time to deal with audience questions, and they've been coming in as you've all been speaking. So I'll start from the beginning. This is addressed to all agencies and a request for publications to be produced in easy to read English for those with intellectual barriers, because these people, when they have no support, are vulnerable and having to do all aspects of disputes alone and need help navigating systems. And the comment is that they often get a bit of a runaround by different services due to their inability to access the service because information is in a too complicated form for them. Now, in relation to AFCA specifically, there's a question, when is the best time to reach out to AFCA? When an issue is identified or only at EDR?
Thanks, Bridget. AFCA has recently, to the first comment, published some easy English forms, so I'm happy to provide some links for that as well, and acknowledge that it can be incredibly difficult for people, whether they have a cognitive disability or are experiencing some other form of mental illness, to negotiate all of our platforms. So I agree with that. The best time to come to AFCA, I think what we usually say is, if you've identified the issue, then you try and speak to the person that you're having the problem with, the financial firm that you're having the problem with. We'll usually, if you haven't discussed it with the financial firm, refer you back there to have that discussion, to give both parties the opportunity to resolve it. And then if it can't be resolved, that's when we'd say come to AFCA. Or if, for example, you're not getting any buy-in or the financial firm's not responding to you.
Thank you, Brenda. Now, Wendy, we have a question for the Telecommunication Industry Ombudsman. Telco providers often state that they don't help or provide vulnerable connections, and they refer people to Telstra. The problem being that Telstra is much more expensive, resulting in vulnerable people who are often on limited income having to pay for a more expensive service. They need to have telco connectivity. However, the cheaper telcos don't provide the same level of assurance and will take people's business but don't provide support if there are connection issues. Is there any way that other telcos other than Telstra can economically provide assured connection? I'm not sure if you can easily answer that. That's a very big question.
Yeah, look, it's a larger policy problem that you know, we make some contributions to, but certainly it's a larger public policy problem as well. I know it's one that ACAN, the Australian Communications Consumer Action Network, also looks at. But in terms of priority, we certainly will prioritise urgent connections in terms of our expectations for telcos. But I think the question is really around that sort of priority assistance kind of framework. And it is true that under the current regime, Telstra is the main provider of that. But we are looking into sort of an ever-evolving telco regulatory system, and I do hope, and you know, we'll certainly make submissions around sort of affordability and accessibility of services into the future. So absolutely, it's a great comment. And on the materials. On the materials comment as well, similarly to AFCA, we have actually just published lots of new materials in easy English, easy to read English. We've also made it more accessible in terms of having videos translated in Auslan and being able to allow people to book a video call with us using an Auslan interpreter. So I can send links to all of those materials as well.
Thank you. There's an observation and a question also for the TIO. Telcos readily provide the product and service without rigour in relation to the credit standing of the client. Do you see this as a trend in the complaints that you receive?
I think that this is an issue that has previously been more prevalent. And there's been a lot of work done in terms of with regulators. There was a big ACCC case around unconscionable conduct, particularly in relation to selling services to First Nations people. There's also been sort of updates to the telecommunications consumer protections codes around credit assessment. So we think it's absolutely an issue that we continue to monitor. We look at from a systemic investigation perspective, but I think in terms of the trend, it was higher. It used to be worse than it is now, which is pleasing to see.
And there's one last question for the TIO in relation to spamming, people receiving multiple SMS messages daily with links to viruses. The person comments that telcos could block these numbers but choose not to. They see this as a systemic issue and is asking what the TIO or what role the TIO can play in stopping this for all customers across telcos.
Yeah, we're a really small piece of that puzzle, I have to say, because generally we're working to resolve issues as between the consumer and the telco, and these are bigger issues. We do look at where there's been multiple complaints about the same sort of type of scam and raise them as systemic issues, but there's also been quite a bit of work, I understand, with industry and regulators around ways to block spam texts and that type of thing. So that work is underway from my understanding.
Thank you, Wendy.
No worries.
Helen, there's some questions in relation to EWON, or specifically in relation to the EPA vouchers that you referred to. Isn't EPA mandated for all retailers? Why should one fight for it?
I think that's probably a question about the review necessarily, perhaps, unless it was a question about that individual case study. It is EPA, I mean, EPA providers, the reviews about EPA providers, and it's a government provided and funded service, not a retailer funded service. But of course, if someone has a voucher, it should be applied appropriately. There was some complexity in that case study because it was a business tariff and a rather tunnel vision response from the provider. So yes, the questioner is right that if someone has an EPA voucher, you would expect it to be applied because it's been granted because the customer's circumstances fit the criteria. I hope that answers the question.
There's another question related to that and to embedded networks. Is there going to be a review of how customers in embedded networks can access EPA in future? It makes it hard for them to help them currently.
Yes, completely agree. And the review of EPA that's going on at the moment is the opportunity for those on this webinar and other organisations to put forward that point of view if they can demonstrate the harm that is actually caused by customers in embedded networks not having access to EPA. And certainly in case studies EWON has provided, that's a position we've put forward because we can demonstrate from our cases that it is indeed a problem. And it's an inequity. If I live in a house and I can get EPA, but the person next door who lives in a block of units can't, there's really no rhyme nor reason to that.
Thank you, Helen. One more comment. Your outreach work format, I would like to see other ombudsmen take that approach.
I think we'll take that as a compliment.
Yes.
And just on the easy English question earlier as well, we've certainly been looking quite carefully at our own materials and are finalising a easy English presentation. But we have produced quite a few videos and some very simple visual graphics over a number of campaigns that are on our website that we can provide links to as well, being very conscious of the inaccessibility issues.
Thank you, Helen. Now we have some questions for the HCCC. I am after some clarification about the interplay between the HCCC and registration bodies. Do registration bodies have access to HCCC files and historic information about complaints made after someone is deregistered or suspended for a set period? For example, lodged after disciplinary action but before applying for re-registration.
Thanks for the question. So as I noted earlier, the co-regulation system is quite complex, and there is actually a national law that applies to all jurisdictions aside from New South Wales, although elements of it do, and Queensland, again, elements of it do. And we operate in New South Wales where there's the HCCC, then there are the professional bodies that I mentioned earlier, but then at a national level there is AFCA, which are responsible for accreditation, registration, and for investigation and prosecution for other states other than New South Wales and Queensland. So in terms of your question, which is very specific, and perhaps we could take it offline if I don't answer it sufficiently now, is we obviously do share information, and we are allowed to share information under the national law. It really does depend at what point in that process we share that information. They don't have access to our files, as in they can't just dip into our case management system or anything like that. But when there is a re-registration application, that's when it's relevant. And depending on whether it's a doctor or whether it's a different health practitioner, we will appear on the re-registration application. So we will have to hand all of the various complaints history and disciplinary history in relation to that practitioner. We can put that before the tribunal, who has to be satisfied. But then there's also another element that has to be satisfied, and that is the APRA registration. So there's a level of complexity that goes along with this, and it's different for other jurisdictions as well. So in New South Wales, it's quite specific, and that's what I'm referring to. But perhaps I'm more than happy to take the question offline if that didn't sufficiently answer it for you.
Thank you, Nicole. It might be helpful because that or the audience member who posed that question had to leave early, so
okay.
That might be great. I can provide you with the contact information offline. We have another question for you to respond to in relation to time limits, and a comment that goes with it, that people, particularly vulnerable people, need time to get over and recover from what they have been through physically or emotionally before they're able or in a position to make a complaint. The process can take extensive time frames, and if people don't have support, it may take them some time, and they have increased vulnerability. So I guess the question is about what time frame or time limit there is in relation to bringing a complaint, and are there circumstances in which that might be extended?
There's no statute of limitations, so there's no statutory bar to bringing a complaint, and we have prosecuted matters that date back to the 90s or sometimes even earlier. The difficulty, of course, with any kind of matter is that the longer it goes on, the less certain people's memories are, the less documentary evidence there might be to rely on, the less willing other witnesses might be to come forward, and so on. So sometimes there's evidentiary issues, but as far as any kind of stop or bar on taking action on a complaint, whether it's down that resolution pathway or a prosecutorial pathway, there is and we would approach each matter on a case-by-case basis, noting full well, just like in criminal trials and in civil trials, there are going to be reasons why people do not disclose early, do not come forward, do not want to participate in a process, and we're alive to that, the tribunal's alive to that. And so really it's just a case-by-case basis, but certainly we wouldn't approach a matter and say we're not going to do anything about it just simply because it's old.
Thank you, Nicole. A couple more questions for your agency. Does the power of the HCCC to investigate extend to the ambulance service?
It does. And in fact, paramedicine is a relatively new addition to registered practitioners. So what that means is I can prosecute a registered practitioner. I can't prosecute unregistered practitioners. So that's a key distinction between those two categories of practitioners. But paramedicine was recently added, and we are seeing some complaints go before the tribunal relating to paramedics and ambulance officers.
And another question, I don't know whether you can respond to this one, directly, but what are the latest New South Wales numbers regarding annual counts of deaths caused by medical error?
I'm not in a position to answer that one, I'm sorry.
This is a question directed to everybody, and I guess in relation to the question about any applicable timeframes for bringing complaints, along with links to websites or contact details that you're going to provide me to share with the audience, it might be good if there are timeframes that apply to the bringing of complaints, if you could advise those, and I can share them with the audience as well. This question is, do each of the agencies have direct contact details within your agency dedicated for financial counsellors to call and seek information?
Given that no one else is answering, I might jump in here. If you call our info line, we don't actually need a dedicated line because it's 9 seconds for sort of 95% of our calls. I think we're paying way too much to have such a great service. But basically, we're very open. And also, I wouldn't mind mentioning around our timeframes for complaints, which our complaints can be business to business, big business to big business. It can be business to government. Pretty much any sort of commercial dispute, but our timeframes in our legislation says that we can deny a request for assistance should they relate to a matter more than 1 year. It's sat around for more than 1 year. Now, it'd be very rare for us to do that. We look at, because ours is all about interest-based, if there is opportunity for a party to take it through court, so basically statute of limitations 6 sort of years plus, then we will normally help with it. We don't have to help if it's in the words of our Act, frivolous or vexatious, but again, it would be very rare that we'd ever call that, given that even something, a small dispute, can matter a lot to a small business, especially in terms of relationship. And sometimes, and normally more than 6 years, we will not be as useful because evidence, as somebody else had mentioned earlier, evidence tends to dissipate. But there have been some cases where there has been some fairly serious matters, in quotes, potential fraud, where we may have gone a little bit further, where maybe documents were fraudulently entered into or whatever, and chase that. But it's rarer to go beyond that six years, and normally we're sitting in about that year sort of mark to hit us, but certainly before the 6.
I can answer for the TO if you like on both of those questions. We have a dedicated line for financial counsellors as well. It's the catchy 1-800-TIO-TIO, and yeah, it's dedicated for complaints and systemic issues. Our wait time is not as good as Craig's. It's 20 seconds from what I understand. But we really encourage financial counsellors to let us know of systemic issues, other complaints they're seeing on the ground. In terms of timeframes, usually we would accept a complaint if it's within the 2 years of first discovering the issue or problem. But between the 2 and 6 year mark, we've got a bit of discretion. After 6 years, it's generally a no-go from us. Thanks.
I'm happy to jump in from EWON. We've got a 12-month from when someone became aware of the issue, but the Ombudsman has some discretion around that and takes a fairly expansive view of jurisdiction and would look at the individual circumstances if someone was a little bit longer than that finding us. We don't have a dedicated line for financial counsellors to call us about complaint issues. We're a bit too little to do that, I think. But we, as you'll have seen in the presentation, we've certainly got email addresses that will go directly to the different non-complaint areas of EWON. So if financial counsellors are just really wanting to talk about the EPA scheme, for example, I know our outreach team talks to them a lot. Similarly, our communications team about resources and so on. But sorry to say you have to wait in the line with others to call our dispute line, but we don't have too bad a wait time either.
I'm happy to respond from AFCA if that's okay. At the moment, I don't think we have a dedicated line for financial counsellors, and I'm ashamed to say, unlike the others on the call, I'm not sure how many seconds it currently takes us to answer a phone call, but I understand it's not too long. One of the things we do offer though, if you're calling with a client who has a particular need or requires additional assistance, is you can flag for a priority call back, and then one of our members of staff will call back and discuss what additional assistance we can provide that client. In terms of periods, because AFCA deals with such a wide jurisdiction and wide variety of products, it's different, and it depends whether you're looking at a superannuation product or a banking and finance product or an insurance product. But again, I'll put some links through in the website. We also do have some discretion in particular areas, and that's in where there's special circumstances. So where the person's been particularly vulnerable. If we're outside, for example, the banking and finance can be about 6 years, unless the product's still on foot, in which case the time limit sometimes doesn't start, then we can go through and assess whether that time limit should be extended.
Thank you, Brenda. Did anyone else wish to respond to the issue about timeframes or make a comment in relation to the availability of Easy English publications?
Bridget,
I've already touched on timeframes. Sorry, Brenda.
No, you're right. You go, Nicole.
Thanks. I've already touched on timeframes. In relation to a dedicated line for financial counsellors, we don't have that, but as I said, we've got an inquiry line that people are able to access. I don't know how long it takes either, so I'm in Brenda's camp. And just on the Easy English point, we do have some documents that fall into the Easy English category, particularly illustrated, that explains the process about complaining about your health practitioner really simply and really easily, and they're on our website.
The only other thing I was going to mention, and I'm sure some more of us on the call have this as well, AFCA regularly engages with your peak body, so Financial Counsellors of Australia, and it has meetings with several consumer advocates, so that we do try and keep in contact and get those issues. But you're more than welcome to absolutely contact through our reg and referral line, or if you think there's a particular issue that you wanted to raise with me, I'm happy to pass on my details to Bridget as well.
Thank you.
I might just jump in, noting the time, to say that New South Wales Ombudsman has on the homepage of the website some easy English forms in relation to how to make a complaint. So they're readily available at the moment, and we're always exploring other ways of making our information more accessible, and we'll keep doing that.
Thank you. Dr. Latham, there was a question for you. Are your clients small businesses and not people dealing with small businesses?
So we don't have clients, but the people that, because we're independent of whatever's going on out there, but it will be a small business on either side normally, and it's not 100%, but normally it's a commercial transaction, not with, say, I don't know, a service you've given to just somebody in their house. That's not the sort of thing we'd normally get involved with. We would get involved with the business to business type dispute or a business to government type dispute. Does that sort of make sense?
Thank you. I'll invite the audience to make further question if they'd like clarification offline. A question for Jacqueline. If the New South Wales Ombudsman receives a complaint from a solicitor that is not seeking to overturn a council decision but expresses concern that the decision-making process is suggestive of possible corruption, would the Ombudsman investigate this?
Oh, that's a bit hard to say. It really depends on the nature of what's being alleged, and if it's moving into the realm of corruption, then it could well be a matter where the Ombudsman has a duty to refer it to the Independent Commission Against Corruption, like any agency head in New South Wales. If there's a suspicion on reasonable grounds that corrupt conduct may have occurred, then the onus is on the agency head, such as the Ombudsman, to refer that matter to the ICAC for it to consider. So it might be a matter, depending on what exactly is going on, that's referred to that body, because that's the agency looking at corrupt conduct as opposed to wrong conduct, which is a slightly different thing.
Thank you. I'll note that there are a couple of questions, but we're just about out of time. So I will provide those questions to the agency concerned and ask for them to respond so that you will get an answer offline. And I would like to say a big thank you to all the agencies who participated in this webinar today. There have been some comments during the webinar about from people who've had to leave early, saying they've really appreciated your presentations, and it's been very informative and helpful. So thank you to all of you for taking the time to participate in our webinar today, which is an addendum, I guess, to our Law Week education events, and it's great to get the information out there. We really appreciate you participating in this Law for Community Workers webinar. And we'll say goodbye to the audience today. Thank you for everybody who's attended, and we will provide the handout via email, and any information that the agencies have mentioned and provide to me, I will forward to everybody who's participated. So thank you, everybody, and we'll end the webinar.